Good morning, sir. I hope your night went well. Good morning, everyone. I want to welcome us to today's continuation. Thank you very much.
Thank you, sir. We go soon start. I'm saying let's just give like it's 12, it's 2 minutes past 10. Let's give like the next 10 minutes and see if we can get up to 100 persons or 50 or 70. So far we have 21. Good morning, esteemed participants. Thank you for joining in early. Please do us a favor. Um, Tell your friends that we are about to commence today's webinar and let them quickly join so that we start in good time. The earlier we start, the more materials we will have. Because if we waste time waiting for people, the time is already set. When it's time, the system will log us off. Thank you.
Good morning, Ho. There's no problem. The instruction earlier was to give a few minutes for more people to join the call. So yes, we are live. We are on. We just need more participants to join the call to get started. That announcement was probably made before you joined. Thank you once again for joining us. Good morning. Good
By
morning.
my time, okay. By my time is 12 minutes past 10. In the next 3 minutes, we should be starting. We have 42 participants. That's a sizable number. While the webinar is ongoing, more people will join. Thank you. But also tell your colleagues that the webinar has started.
Good morning, everyone.
Good morning.
The session will soon begin shortly. Let's just wait for a few more participants to join. So, good morning, distinguished colleagues, ladies and gentlemen. It is 10:15. I think it's better we just start now since we have a bit of a full house. So I welcome you all to day 2 of this webinar, which is organized by the Medical and Health Law Committee of the NBA Garki branch in marking the World Patient Safety Day. I am Hadiza Abubakar, and I have the honor of serving as your moderator for today's session. So before we go further, I want to kindly state that while today's presentation is ongoing, please feel free to type your questions into the chat box. And at the end of the session, we will take them up during the Q&A. All right, so ladies and gentlemen, it is with great pleasure that I introduce our host and chairman of the NBA Garki branch, Mr. Anthony Bamidele Ojo. Sir, we invite you to kindly give us your welcome remarks.
Good morning, distinguished ladies and gentlemen. I want to welcome each and every one of us for the second session of our webinar, which began yesterday on a very educative and inspiring note. I believe that all of us who participated fully and actively in yesterday's session did learn a whole lot, and I believe we're going to learn more this morning. So I want us to encourage all of us to sit tight and enjoy all that we're going to be learning from the gentleman who will be talking to us. And I wish us a wonderful day ahead. And I also hope that for those of us who are members of MBA Garki branch, we would all be at the branch meeting later today. Thank you very much.
Thank you, Mr. Chairman, for the welcome address. Now, allow me to introduce our convener and speaker for today. Our convener and speaker is no other than Mr. Ebenezer Egwatu. Mr. Ebenezer is a legal practitioner, a medical law consultant, and a passionate advocate for patients' rights and safety. He's the principal partner at Law Fund Multidisciplinary Consult in Abuja and the founder of the Lawyers Arise for the People Initiative, LAPI, a patients' rights advocacy NGO. Mr. Ebenezer also serves as the chairman of the Medical and Health Law Committee of the NBA Garki branch, and he has trained hundreds of healthcare professionals on patient-centered care and preventing medical negligence. He also has contributed to Nigeria's National Patient Safety and Care Quality Policy and Implementation Strategy 2024. Ladies and gentlemen, please join me in welcoming our speaker, Mr. Ebenezer. Mr. Ebenezer, over to you.
Good morning, esteemed colleagues. Thank you once again for making out time to join us in day 2 of the webinar, which we started yesterday. I want to thank the chairman of the branch and the executive committee of the branch for the support, total support they have been giving to this committee, and that's why we are able to do what we are doing. I also want to thank my committee members, from the moderator to the technical person to those online, for their support and teamwork. That is why we are doing what we are doing. And this month, for giving me the privilege to serve as a facilitator. I recognize and commend our brothers from the medical community who are on the call, both on YouTube and on this Zoom platform. So we will go straight into today's presentation by starting from maybe an overview of what we did yesterday. Let me just share my slides. I have tried it earlier and it showed, but it seems to have a mind of its own whenever we want to share to, okay. Let's see. Can you see my slides, please? Confirm.
Yes.
Okay, thank you. Okay, so yesterday we looked at what who a patient is, what patient's right is. We examined the sources of patient's rights, globally, from international conventions and treaties to our local legislations to laws of the states, acts of the National Assembly. We looked at other sources like regulations and very important code of professional ethics of the healthcare, the different various healthcare disciplines. We also looked at rights of the patients that are enforceable in Nigeria, from right to information to consent to confidentiality to access to medical record to privacy and all that. And we are supposed to continue today by looking at conducts, attitudes, or acts that constitute violation of patients' rights, because you need to know your rights. We have known the rights yesterday. Now, how are these rights violated? What could be done? What will you see? And you say, oh, they have violated my rights. Because it is not enough to just know the rights. What happens when, what happens where you don't know how these rights, because you have known your rights to information, what could be done, and you say, okay, my right to information has been violated. What could be done, and you say, my right to privacy has been violated. That's what we want to consider today. Okay, we start by saying that contract for medical service is a special kind of contract. I mentioned that yesterday, with express and implied terms that confers right and obligation on the healthcare professionals and the patient simultaneously. So where you go to hospital and as an ignorant, in quotes, patient, all you know from your end is that you are going to hospital to receive treatment. Most times you do not know that you are entering into a legal relationship. The same is also applicable to the doctor. To the doctor, he believes he has a professional duty, he has an ethical responsibility to perform, but he is not aware that he is entering into a legal relationship. Because I tried to restrict the content of this lecture, I didn't bother to go into how doctor-patient relationship is created and all that. Now, the underlying or very paramount implied terms of every contract or contract for medical service is that the doctor will render competent care. Now, the doctor has been trained and certified and registered to practice medicine according to law, particularly the Medical and Dental Act. Now, the doctor owes the patient a fiduciary relationship. The balance of power between the doctor and the patient is like this. The doctor is high up here, the patient is down here. So prior to the coming into existence of patient's autonomy, what we had was paternalism, where the doctor was the alpha and omega making decision for the patient. If the doctor says bend to the left, the patient will bend. Bend to the right, the patient will bend. Why? Because the doctor has been trained and the society has reposed that confidence, and the government and certifying bodies, regulatory bodies like the Medical and Dental has also presented and endorsed this person by way of registration to say this person is a qualified doctor. So with all this, the doctor is not a magician. I need to stress that. Then I also need to put out this disclaimer. It is not every time that something goes wrong that the doctor is negligent or that the doctor has violated the rights of a patient. What the doctor owes you is to treat you with the required skill and care of a medical practitioner of his standing. He owes you competent care. He is not in charge of the outcome. So if there is a particular medical procedure or a standard of care that if you take the patient to America, that's the procedure that we take or use. If you take the patient to India, Israel, South Africa, and our own Nigeria, they will use the same standard. If the doctor does that and the patient does not recover, the doctor has not firstly violated the patient's rights. No, the doctor is also not negligent. Where we talk about violation is where there's a departure from the standard rules of their practice. So by our earlier definition of patient's rights, we said that any conduct that reduces the professionalism, if you remember the right we discussed yesterday, that patients' rights are those rights that guarantee professional, quality, transparent, and the safe healthcare service delivery, as well as respect to the person of the patient, the dignity of the person of the patient. So any conduct that deviates from this becomes a violation. And these violations can manifest in different ways. So we look at one of the examples or ways that a violation can manifest is where hospitals deviate or turning patients away in emergency situation. We looked at section 20 of the National Health Act, and that section says that hospitals should not deny patients treatment in emergency situation for any reason. So, and we said that any reason could be you do not have a card, go and buy card. And you know the challenge, I forgot to put that in my recommendation. So let me say it now so that I don't forget when I get to recommendation. There is need for us to begin to redesign the building of our hospitals. You will see that emergency care units, accident and emergency, is closer out than where they are selling card, particularly in tertiary healthcare facilities. Where the accounts department is somewhere far that you have to walk in some places 15, 20, 30 minutes to get to the other side. And then where you where you go and pick card is in another place. So to solve that problem of patients going to get card, that's of course a standard hospital protocol. You need to be documented rightly that you are a patient in their care. But to solve that problem, particularly in emergency situation, while you still have, if you cannot redesign and bring those different spots together, have a one-stop shop within the emergency units, within the accident and emergency ward. Have a cubicle, a table, just have a table there. What you put there, put few cards there. Put one POS there for payments. Put one laptop there. Let a staff sit there. That one is for emergency. So that you do not say this patient has not been documented, so we will not treat. I forgot to make that recommendation. I'll include it in my recommendation. So what hospitals are supposed to be doing, if redesigning one, bringing the payments spots closer, then in emergency units, have a cubicle, a one-stop shop where you have card, everything you want to do, they are treating here, the person is here. If you want to let them do it, it will save time. So turning patients away during emergency is a violation of section 20, and there is a consequence for that: 100,000 naira fine if found liable, or imprisonment of 6 months with not more than 6 months. Then surgeons conducting procedures without adequately explaining to the patient or ignoring their religious beliefs. Now, yesterday we talked about a religious sect that does not receive blood transfusion. They actually carry cards about. They actually carry cards about. So the protocol is, if accident victims are brought or patients come in emergency, the first thing is to search them. See if they have their card that is telling you do not resuscitate or do not transfuse blood. As a healthcare professional, you are bound to respect that decision of the patient. We talked about patient's autonomy yesterday too, that the patient is the Lord and Master of his body and has the power to determine who, where, and how that body should be touched. Then where health workers share patients' information. This one is also a violation. In fact, a lot of health workers do not understand that when we say health workers sharing patient information without consent or handling their file, it is not sharing it to an outsider. That is part of it. But even within your community, even within your hospital, doctors treat patients in teams. So you have a consultant leading a team of doctors, then you have nurses assisting and playing one role or another. That team that is managing that patient, they are the people that are supposed to have access to the patient's information. The example I give is this. Let's say a man comes in for, the man has a cardiac challenge, he has a heart issue, and a consultant cardiologist is attending to him. While they are attending to this man, they ran some tests and now discover that the man has HIV. Then while he's treating, after he has treated, he's back to his office, and his friend, the cardiologist friend, who is a gynecologist, they are in the same hospital. He's also a consultant gynecologist, and now comes to visit his friend. In the course of discussion, the cardiologist now says, this man I'm managing, I just discovered yesterday that he has HIV and he has been wasting our time since. That he was talking to a colleague, a doctor, but that doctor is not in his team. That doctor is not even in his area of specialization. That doctor is not a member of his unit for managing that patient. So it is a violation of the patient's rights to have his medical record confidential. Patients being tested, treated disrespectfully, harassment, this one, we mentioned it yesterday, even discrimination. You need to talk to your patients with respect. We are all humans. Even patients living with disability. Sometimes you go to the hospital because a patient is blind and has been standing or waiting with his people. Then other persons that he came before, because you feel he cannot see you, he cannot challenge you, then you ignore the patient there and start attending to every other person. Whenever you now feel you have his time, out of pity, you now want to pity and attend to this blind patient. No, that is disrespect. You are discriminating against that patient. Particularly in labor wards where they use all kinds of vulgar languages and abusive languages or words against mothers who have come to deliver. There's a way you can tell them to push, fine and good. So communication is also important. I once witnessed a scenario when I was nursing my uncle in the hospital. I stayed 3 months in a federal medical center. So that exposed me firsthand to issues of medical patients' rights violation and medical negligence. Now, a man was supposed to be amputated. What are you supposed to do? You need to prepare this mind mentally, psychologically, that this is not the end of life. There is still hope after this. You tell him what to do. You can use crutches. If you know people who have been doing well, you give examples. But what did this nurse do? Oga, what's your problem? Are you the only person they want to amputate? Even my father, they amputated him and he didn't die. What's your problem? Now, that is height of lack of emotional intelligence, one. Two, that is height of ignorance as to doctor-patient communication skills. Then, as far as I'm concerned, that is disrespectful. Then, being charged for items or services not disclosed. We talked about this yesterday. Now, we cited the example of the case of Mr. Jonathan against Benue State University Teaching Hospital, where because of 2,500 naira that the hospital insisted they must have, the hospital is now paying a fine of 250,000 or damages of 250,000 to the man, and the Court of Appeal still ordered them to refund the 2,500. So this comes under what we call medical fraud, where either you include services not rendered, or you repeat the same, or you render one service and bring in 3 different bills under different names for that singular service. But that's not the purpose of this class or this webinar. Facilities taking long or delaying access. Now, there are 3 delays that leads to death of patients. One is delay at home, where things happen or there are signs the patient has not presented himself to the hospital for care. The patient is procrastinating, the patient is praying, the patient is expressing faith in God. Those are not bad, expressing faith. But once you see signs, go and present. So most times patients present where the sickness or ailment is already at an advanced stage. That is one delay. 2 is delay on the road. We know how our roads are. So some places are not accessible. People who live in interior areas. So it takes them some days, a lot of hours to get to the city to access a healthcare facility. That's delay number 2. Then we now come to delay in the hospital, which is what we are talking about here. So I had a case in 2016. This man was married. He and his wife, they had waited for 8 years to have a baby. In the 8th year, the wife took in. They were registered in a private hospital, did everything. The day of the delivery, the woman delivered via CS. No, she delivered normally, then through vaginal birth. Then all of a sudden, her BP shot up. And those babies actually came preterm. So firstly, they had to put the babies in incubator and now referred this woman to a tertiary hospital. They didn't just refer, they brought their ambulance, and a matron, a nurse in the private hospital, followed this woman with referral letter. They went to a tertiary hospital. They spent almost 2 hours in the ambulance waiting for documentation. Go here, go and pay here, go and buy a card here, go and confirm payment here. And the woman died. Of course, we went to medical and dental council. Now, that delay in the hospital is a violation of patients' rights, especially where it is emergency. We have already said that Section 20 provides hospitals should not reject or deny patients treatment in emergency. But they might not outrightly tell you off or dismiss you, as I put it yesterday. But delay is actually a violation of that Section 20. Clinical trials or experimental procedure without clear consent and pressure on the patients to accept. Especially in our teaching hospitals. There are teaching hospitals, yes, and the only way they can expand the medical jurisprudence is through those experiments. Those experiments. But the issue here is that consent of the patient, valid consent of the patient, must be sought and obtained. You see situations where you enter a hospital in the morning, a consultant leads a team of residents, resident doctors. They just passed out from medical school and they are doing their residency. Then he leads them. They come to this patient, stay with the patient for 1 hour, stay with the patient for 1 hour, 30 minutes, ask the patient all manner of questions from medical history to family history, to who has this, to who has that, information that are very personal to the patient. And when they are done, they will not give the patient as much at least paracetamol. The patient will not get any medication of any type. They will just come, okay. I also witnessed that scenario, multiple of that scenario. This man was vomiting blood. Whenever he's transfused, he will vomit the blood. In fact, as you are done transfusing, he will vomit that blood. So the consultant was now asking the patient, the residents, what do you think this man needs? What do you think this man needs? Okay, in this case, do you think if we gave him 6 pints of blood that he will vomit it? Do you think? I'm like, then I didn't even know what I know now. But with what I'm doing now, I am recalling those experiences. So what they are supposed to do before we are not saying don't conduct clinical experiments. No, we are saying before you do that, get valid consent from the patient. Then poor sanitation in wards, infection. We talked about hospital-acquired infections yesterday. Then lack of safety is also a violation of patients' rights. We talked about, I gave example, it's in the news where armed robbers will go to hospital, dispossess doctors, dispossess patients, and go away. It's a violation of the patient's rights by the healthcare facility, because the patient has a right to clean, safe, and secured healthcare environment. Of course, physical harm or loss of life, this one is self-explanatory. There are people who are lame today because of injection. It could be wrong injection, it could be wrong dosage, it could be wrong administration. Now, there are 6 rights of drug administration. There are more than 6 actually, but the most popular or the most important, these 6 rights of drug administration. One, is it the right patient? So we have issue with patient identification. This person I want to inject, is it the right person? There was a case in Korea some time ago. A woman went for abortion. Another came for antenatal care, and they operated and they did abortion on the one that came for antenatal care because they were not working on the right patient. So, is it the right patient? 2, the drug or service I want to render, is it the right drug? There are some drugs that have similar names that you can easily mistake this for the other one. Is it the right drug? When you have gotten the right drug, is it the right dosage that I want to give? Is it 2 milligram? Is it 4 milligram? Is it 5? Is it 10 mil? Is it the right dosage? So whether you give more or less, that is wrong. So it should be the right dosage. Now, is it the right route? Is it by ingestion, swallowing, or by injection, or by infusion? So is he supposed to swallow? Is he supposed to take injection? Even if it's injection, is it on the buttocks or intravenous? So we look at the right route now. The right time. Is it supposed to be twice, or particularly if it is antibiotics? Some they take every 8 hours. So is it the right time for this person to take? Or because I want to go for a particular meeting, or because I want to go and meet somebody, or because I want to quickly attend to something else, I now give the person his medication by 12 o'clock instead of waiting till 2 o'clock to give that medication. These are small things that could lead to death. We are talking about physical harm or loss of life. Now, right documentation. Okay, you have given this patient this drug, your documents, fine. What was the patient's reaction when you gave that drug? you document, so that the person who is coming to take over from you, if the patient reacted, the person will now know whether to escalate the reaction of the patient by reporting this was the, or the person will just come and administer a tranquilizer or a neutralizing drug, or even stop administration of that medication. Physical or physiological trauma, loss of trust in healthcare system. Yes, we get to see re-traumatization as one of the reasons why some patients or some victims refuse to seek redress. Now, some healthcare professionals transfer their aggression. If we were dealing with medical negligence, you will know that one of the causes of medical negligence is fatigue, burnout of healthcare professionals. They also, every day they care for us, every day they attend to us. Sometimes nobody cares for them to say, oh, doctor, how are you today? How are you doing? You will rarely get that. So is doctor, my head is doing me like this. Nurse is doing me like this at the back. So they also have their own psychological challenges. And sometimes, unwittingly or unknowingly, they transfer this aggression to the patient, and it becomes a violation of the patient's rights. Legal liability for hospitals, practitioners. No, sorry, I'm in the wrong place. Sorry, please. Okay, I'm in the right place, but wrong explanation. Consequences of violations of patients' rights. Physiological trauma, loss of life, and harm. I used to tell people that medical negligence is not like carpentry, or patients, medical mistake or error is not like a mistake by your carpenter. If your carpenter didn't nail your chair well, two things are one out of two. The nail, you could sit on the nail and the nail will harm you. The chair might not carry your weight, you will fall. You buy another chair. If a car has accident, you replace the car or you take it to mechanic. But where life is lost, it is irreversible. There are people who have lived with physical harm as a result of what we just spoke about, wrong injection, error. In fact, this thing I was talking about, on the 16th, we had a technical session organized by the patient safety desk of the Ministry of Health. And one of the facilitators, God bless him, he was talking about communication and respect for residents. And he said he was conducting a surgery. They were trying to remove, he's a pediatrician, they were trying to remove a kidney, one bad kidney. And he had tied the vein, tied everything, and he thought it was a suture. And he wanted to cut. And the junior doctor, the resident that was beside him said, Oga, it seems like it's the other vein to the other kidney that you tied. Oh. He said inside him, he got very angry. Say, who is this boy that is coming to tell me what I've been doing for long? But he now wanted to reconfirm that it was that he did the right thing, and then face the resident and congratulate him, only for him to discover that the young man was right. And fortunately, he had not cut. Now, it could just be that singular mistake and a life is lost. That's the consequence. Of course, legal liability, we talked about 250,000. We talked about 500,000 in Anambra State, 5 million in Ebonyi State, 2019. A woman went to deliver and she came with her father. The doctor on duty, the doctor on call was not present. Nurse is called, He wasn't present. He wasn't available. They sent message. He didn't respond. The man now says, please, can you people discharge us? Let's go to another hospital. They say, wait, doctor is coming. Delay. Doctor wasn't forthcoming. When they decided to now come and attend to the woman, she gave birth to a dead baby. Stillbirth. And they sued. The court awarded 5 million naira against them. They are still on appeal as we speak. That matter is on appeal. Public health implication, people avoid seeking care because they have lost trust. I mentioned the case we did, the mama yesterday, dialysis case. Because of how they were handling her, she says she's no longer doing. She preferred to stay in her house and die. So where patients' rights are violated, they lose trust in healthcare facilities. There are sometimes you will hear cases like, is it that hospital? That place now mortuary. Over my dead body, will I allow my relative go to that hospital? You must have heard something like that. That is public, how do I put it now? That is public proclamation of loss of confidence, passing a vote of no confidence on a healthcare facility that is supposed to save our lives. Of course, socioeconomic cost. You know that where it is more expensive to correct medical harm than treating initially. It is more expensive actually. So some will be permanently damaged, loss of income. Then, because they have lost their income, they are now dependents. Not only is it affecting them directly, the family begins to put their own income. We have one of our colleagues in this town, in Abuja, a healthcare facility mismanaged him. If he's aware of this webinar, he will be here. He had to go to India to correct his spine. In fact, after mismanaging him here, they told him that if he wants to be alive, he should just make up his mind to remain on wheelchair. He's a practicing lawyer. He's back on his feet. He's in Abuja, practicing here in this town. His case is before the Medical and Dental Council against that health institution. Then we look at available redress mechanisms. One is administrative redress. We talked about it yesterday. Administrative redress. How do you explore administrative redress? When things go wrong, you report to the CMD. The mama's case example I cited yesterday, what we did there was administrative redress. I called the CMD. He gave us appointments. We went and explained, this is the challenge, this is the challenge, this is the challenge. The man apologized. The man says, okay, going forward, we will treat mama at no cost. She will be taking her dialysis at no cost. In fact, what actually happened was, after the first meeting, the hospital continued charging them for dialysis. In fact, they did 2 more sessions of dialysis and paid. Before the guy called me, I said, barrister, they are still collecting money from us. So we went back to the CMD. The CMD invited the accountant, wrote a note and handed to him and said, for this patient, nobody should charge this patient money. That was administrative redress. Institutional redress is sometimes overlooked. Now, the National Human Rights Commission is there. Public Complaints Commission is there. People can go and make complaints, particularly indigent persons who do not have wherewithal to pursue litigation. Yes, you might say, what power do they have to award compensation? We have done a case before the National Human Rights Commission, although a panel was set up and they used the National Human Rights Commission. Then it wasn't medical related, even though there was an element of it where they needed to do autopsy to confirm the cause of death. So, but at the end of the day, there were 1, 2, 3, 4, 5 parties. We got 5 million for each of them. One lost his father, but out of foolishness, the community people say, well, with 5 million replace the death of your father. If you collect 5 million, right? Only him did not collect. The other people signed and took their 5 million. And this thing was done in a space of maximum of 3 months. The hearing, the everything, maximum of 3 months. And later in the year, they got their money the same year. But if it was in courts, we are lawyers, we know. Then professional redress, you go to the professional body. If it's a nurse that is involved, you go to Nursing and Midwifery Council. If it's a doctor that is involved, you go to Medical and Dental Council of Nigeria. The Medical and Dental Council does not spare any erring doctor. I can tell you that free of charge. If a doctor is found liable, they will punish. They are the equivalent of our Legal Practitioners Disciplinary Committee, LPDC. They are their own equivalents. Now, what's the procedure? Because that's where people miss it. If you are going for a professional redress, there's a procedure. You do not, for administrative redress, you write a letter of complaint. That's what I advise. Write a letter of complaint, go and submit it in the office of the CMD. Ensure you get acknowledgement copy. That is documentation. So if you are not satisfied with administrative redress, or you do not want to use institutional redress, you can go for professional redress. But the procedure is different. Here, you require an expert. That's the truth, or you mess your case up. So you go to court. That's your complaint to the Medical and Dental Council. You go and file an affidavit. You swear, you depose an affidavit and go and file. So your affidavit, your name, of course, your particulars, then the particulars of the hospital. You were admitted in ABC hospital, your card number to show, or hospital number to show that you are a patient in that hospital. You put all those things and attach them. Then the name of the doctor that you are complaining against. Now, Medical and Dental Council does not regulate hospitals. They regulate doctors. So, the name of the doctor, you state your facts, what happened, the day, the time, and all that. When you finish, you go and file it there. They will take that, your complaint, and forward it to the doctor against whom you have complained. Then the doctor will respond to your complaint. After that, you file a reply to the doctor's complaint response. When they have done all this, they have investigative panel. The investigative panel will sit and go through the facts. If a prima facie case is established against the doctor, then a panel is constituted and the doctor is tried. The doctor has a right to a lawyer to defend himself. Now, the decision of that panel is equivalent to the judgment of a high court. The panel can only hand 1 out of 3 sanctions. They can caution the doctor. They can warn the doctor. They can suspend the doctor for 6 months. They can strike the name of the doctor off the record and the person of the register, and the person will cease to practice as a medical doctor in Nigeria. So that is administrative or professional redress. Now, there is nothing that stops you from using a combination of professional and legal redress. Legal redress is twofold. We talked that someone asked a question yesterday, when does criminal liability arise? When does civil liability arise? I hope the person is here today. For legal redress, there are twofold. If it involves loss of life, we are looking at either murder or manslaughter. It is a criminal matter. So the approach, okay, let me do civil first. For civil redress, you can file an action in court. We cited examples. The woman who was detained with her husband over the loss of their 11 months baby, they filed a civil action in court and they got 500,000. The man who was charged to 2,500 that the hospital did for a consumable or service the hospital didn't render, he got 250,000 naira. So that's civil redress. Now, for criminal, if it involves criminal element acts, I talked about procuring an unauthorized abortion yesterday. I talked about organ harvesting, theft, loss of organ, that somebody comes to your hospital for a surgery and the person's kidney is stolen without the person's knowledge. It happened in Jos last year or 2 years ago, but NMA came out to say that the person who did that was a quack. He was not a registered member, was not a registered medical practitioner. So in such a case, you report to the police. The police will investigate the matter, and of course, the person will be taken to court and tried. So that is it for legal redress. Then we look at challenges in seeking redress. What are the challenges in seeking redress? One is lack of awareness among patients of their rights. And in 2014 or 2015 or 2016, I made a post on Facebook on patients' rights because I do advocacy on Facebook. So when I made that post, my classmate, my callmate, a lady, she called me on phone. She said, Ebenezer, that thing you posted, is it true? I said, yes, that's the law. She said, hey, do you know that my husband's doctor, who has been their family doctor for more than 20 years, the way he attended to my husband is contrary to everything you have listed here. Now, why am I telling this story? This person that called me is a lawyer. She is my callmate. And she doesn't know her rights or the rights of her husband as a patient. How much more the uneducated person in the village? How much more? So there is lack of awareness. How old is the National Health Act? 2014. That law took 10 years of consistent advocacy to come into existence. So the National Health Act is relatively new. This is the 11th year of that law. But that is not a valid excuse why people should be ignorant, because there is no advocacy. So people do not know their rights, whether lawyer or patients, they don't know their rights. One. Two, ignorance of where and how to seek redress. Some people don't know how to seek redress. Some people don't know where to seek redress. In 2023, November or December, there was an incident in Abuja. A lady, well, it was in public domain, so I can call her name. Her name was Greatness. She was thrown out of a moving vehicle by these one chance operators, according to the story. So they rushed her to a particular healthcare facility in Abuja. And the story went that they rejected her and she died. So I wasn't aware of this. Then a colleague just called me, said, Benisa, something happened. I'm giving somebody your number. They will call you. As I was dropping the call, I opened Facebook to check what's up. I now saw somebody saying, God help me, that the hospital have killed this person, this. Under the comment section, I now wrote the provision of section 20 of the National Health Act, only for them to call me back and we started talking. Guess what we were talking? I was advising them on the legal steps to take. You people want an action? This is what you are supposed to do. This is what you are supposed. They say no. Somebody said, call Mr. Macaroni. Somebody said, I have somebody in AIT. Somebody said, call Tunde Ednot. Let them escalate this thing. Now, when they wanted to engage me, I said, okay, firstly, get me the consent of the family of this deceased. There were members of her professional association that wanted to help. I said, get me the consent of the family of this lady, because you will get to see part of the challenges that midway, your patient, your client, the person you are advocating for, will abandon you, and you will look like a fool if you want to continue seeking redress. The bottom line of the story is that they didn't engage me. I saw a few posts on Facebook. It was on air. Then the minister set up a committee, a panel. The panel looked into the matter. The panel came out and said that the woman was BID. She was brought in dead. And that was the end of the case, because they didn't know where and how to seek redress. They were seeking redress, but how? They didn't know. I even told them that this lady was the breadwinner of her family. We can get compensation for the family. They said no, what they don't want anything money involved. All they just want is to bring this awareness so that that kind of behavior will stop. Then later they say that when I mentioned the amount I'm going to collect, they say no, that 2 lawyers have volunteered to do the matter pro bono. And I told them, I say, that matter will not succeed, except those lawyers are medical lawyers, because it's a technical area. How do you gather your evidence? How do you present your evidence? What's the quality of the witness you're calling? It's a technical area. There's a matter, a senior person I respect, I hold in very high esteem did. But he lost. It was a very good case. He lost. Why? Because there was a nexus that he didn't put in that case. There's a component, causation was missing. And he said, Beniza, this is what happened. Why will the court give this judgment? Well, the matter is in Supreme Court. When I read the Court of Appeal decision, I knew why the court gave that judgment. So it's not enough to carry lawyer. That's why you are here. That's why we are building your capacity. So that after now, if you get such a brief, you know what to do and how to go about it. Let me just say, since have mentioned that, if you are engaged and you want to call a witness, if the person, the accused person or the defendant is a consultant, don't go and call a resident doctor as your expert witness against a consultant. The court, the quality of evidence of that consultant, the weight of his evidence weighs more than that of a resident doctor. If the case is against a cardiologist, don't go and call a nephrologist as your witness. Don't go and call a general medical practitioner as your witness. Don't even go and call a cosmetic surgeon as your witness. If the case is against a pediatrician, a consultant pediatrician, your witness should be another consultant pediatrician who knows what this man knows. If this person is the case is against a neurosurgeon, and you go and call a nephrologist as witness, you are wasting your time. So these are the technicalities. How do you even gather your evidence when something goes wrong? These are technicalities. But out of passion, because you are a lawyer, you want to show you are a lawyer and prove you are a lawyer. You write, you put your processes together and file. And when you have filed it and the judgment is against you, you either accuse the bench of compromise or you look for one story and tell the client, instead of admitting that the fault was yours, you didn't have the technical expertise to handle that case. Illiteracy, both on the part of the patients and sometimes, on the part of the patients. There's a project we are doing now that I wouldn't want to put out here now, but when it's ripe, you will get to hear about it. Weak enforcement mechanism and regulatory oversights. Now, we have enforcement mechanisms, but how strong are they? What about regulatory oversight? How strong are they? Now, these are challenges. For example, if the president comes in, it's the president that constitutes the council members of the medical and dental council. The council is the president that constitutes them. If he decides for whatever reason to wait for 6 months, to wait for 1 year before he constitutes council, what do you do when you have a complaint? It will certainly affect you. Yes, you will. The body is there. The body is there. The regulatory body is there. But do they have the power to function at that moment? That's another question. We look at cultural barriers, patriarchal decision-making, respect for elders, respect for traditional institutions. It's a barrier. A lady was misdiagnosed of breast cancer by this same, this is in public domain, so I will say it. A lady was misdiagnosed by breast cancer by Benue State University Teaching Hospital, and one of her breasts was chopped off. Then an NGO took up her case and was sponsoring her treatments post-surgery. The hospital referred her to another hospital in Abuja. The second hospital was now demanding for histopathology reports. When you have done the surgery, you need to get a histopathology report to know what caused this, what further line of treatment are we supposed to do, and all that. And the report was not forthcoming. So the NGO that was helping her contacted me, and I wrote a letter of demand for that report, for the test results, and handed this to this lady. I wrote in first person as if she's the one writing, and she went to deliver. I wrote on her behalf, she went to deliver. I said, go and deliver this letter. She went, took the letter I wrote and gave her uncle. Her uncle read the letter. After reading, he said, Kai, this letter is too harsh. No, this letter is too indicting. The man edited the letter and now gave her back to go and submit. She went, as far as I'm concerned, she submitted tissue paper because there was nothing in the letter again. So that's an example of cultural barrier, patriarchal decision-making, respect for elders, respect for traditional institutions. That is how it affects seeking of redress. Now, when the hospital got the letter, they said, okay, let us employ you. Let us employ you. Bottom line, I was angry. The organization that sent her to me was angry because she has already watered down the action plan we have put in place. It was when she submitted that, the plan was when she submits that letter of demand, and the hospital refuses to respond, I can now write with my law firm's letterhead as her lawyer, and we take it up from there. If they refuse, we are already building evidence before we go to court. But she truncated that. What she's doing today, she's on Facebook. Occasionally, she will just come and shout, they chop off my breast, they chop off my breast, I need justice. But she, when the process of justice was set in motion, she truncated it without even knowing what she was doing. That is it. Then there are cases where you take up a matter and the people, the defendants, will go and beg our appeal to the pastor of the claimants. And the pastor of the claimants now appeals to the claimants. And the claimant will not say no to her daddy GO or to her imam or to her traditional ruler. And the claimant, without telling you, withdraws them, ceases to appear, loses interest in the matter, and you will look like a fool if you continue pushing. It will now be as if, it will now look as if you are inciting the claimant. So you hear cases, I have begged her, the woman has agreed, it's the lawyer. It's the lawyer that doesn't want this case to end. Then improper evidence gathering. I've mentioned this. This one is a course of its own. How do you get your evidence? Because they are going, we said you have a right to medical record. If they do not give you the medical record, what do you do? If you insist on getting the medical record and they give you a tampered medical record, because that's the next thing, evidence tampering by healthcare practitioners, professional and facility. If they give you a tampered medical record, how do you know that this record has been tampered? So these are challenges to seeking redress. Religious barrier, I've mentioned it. Another aspect of religious barrier is vengeance belongs to God. So don't bother. The Lord giveth, the Lord taketh. That's how the Lord wants it. Then another example of cultural barrier is don't disturb the spirit of the dead. Especially if you say, let us conduct autopsy. You say, how can they come and be butchering this person? No, 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 no. It can't work. The spirit of this person will be angry. In our family, they bury you intact. They don't put it. So you hear all manner of cultural beliefs that prevents you from seeking redress when there is a violation. Then I talked about emotional traumatization. That the person begins to relieve the pains again. And because the person cannot handle the person, I don't want, I am seeking closure. The best closure you will seek and have actually is to have a sense of justice being done. Okay. Challenge is still lapse of time, limitation of action. Medical negligence action should come to court within 3 years of that event happening, of that incident. So if there is lapse of time, this incident happened in 2020, we're in 2025. We have already lost 3 years. But there has been an argument as to when does time start counting. Does it start when the incident happened, or does it start when the victim realizes what happened to him or her? I belong to the school of thought that says it is when the victim realizes that this is what happened to me. That is when cause of action has arisen, and that is when time starts counting. That is my own philosophy in that regard. There was a case in 2014, my lecturer referred that case to me, and one customary court judge, but he's late now, God rest his soul. I appeared before him And when he got to know that I do medical law, next time he said, Benisa, there's this case you have to do. That case, a woman went for surgery. She didn't know that her womb was removed. Up north, I won't mention the states. She didn't know that her womb was removed. Then that's not just the problem. When they were suturing, they now ruptured her bladder. She started having urinary incontinence, leaking of urine. She couldn't control urine. So she went in for a corrective surgery. That was when it was now discovered that her womb was not there. Then they now asked her what happened. All she remembered was the surgery she went for. And a lawyer was already handling their case. Then when this judge, my judge now saw a medical law, he said, come and help these people. He gave me the lawyer's number. I called to come and assist. Immediately I called the guy, said, who gave you this number? How did you know I am handling this case? We spoke. I said, okay, this is why I'm coming to assist you. Somebody has detailed me to come in. He said, well, if you want to do anything in this matter, you have to come and meet me in my town up north. I said, I'm resident in Abuja. Can we see the file? Can I see the file? Can I say you have to come and collect it? 1, 2. Now it's okay, just wait for in 2 weeks' time, I'm coming to Abuja. When I'm coming, I'll bring it. Bottom line of the story is that we investigated and discovered later that the lawyer compromised. And that action, later the hospital paid the family 200,000 naira. Why I told this story, the woman didn't know when her womb was removed. It was when she went for corrective surgery that she realized. So the time we start counting from the moment she realized that this is what has happened, okay. Then we have poverty, cost of seeking redress. This one doesn't need explanation. Somebody needs to eat first before the person goes to court talk about rights. Then stigma and discrimination. Then inadequate data documentation, record keeping. We've talked about all those yesterday. Inexperience on the part of lawyers in presenting the case for the victim. I've talked about that. Legal and bureaucratic obstacles. We know about adjournments. We know about delays. We know all that. So no need of repeating them. Then barrier still continues. Denial of access to record by healthcare professionals to facility. We talk about it. Threat to life in some cases where a victim is being threatened. If he doesn't withdraw, if anything happens to this person, those things do happen. Confusion on the part of the victim. The victim doesn't know what he or she wants. Last year, no, 2 years ago, okay, 2021, 17th September 2021, World Patient Safety Day 2021, my organization went to train students of FCT School of Nursing and Midwifery on promotion of patients' right. That year, the theme was respectful maternity care and respectful maternity and newborn care. That was the theme for World Patient Safety Day 2021. So we felt, since it has to do with maternity, let's go and train nursing and midwifery students on promoting patients' rights, tackling medical negligence and promoting patients' rights, the role of nurses and midwives. That was the theme of that training. Then when we were done, you know, when you are talking, you train, you go. I left my number. That was 2021. Then 2023 or January 2024, no, 2023, I received a call. I received a message, a long message. One of the student nurses had a challenge. She was pregnant and went to a facility to deliver, and she lost the baby. Now, she chronicled she's a nurse. So she chronicled what happened and where they missed it. Then, but her complaint was that after she delivered through CS, but that after she was wheeled out of the theater to the ward, 48 hours after she left the theater, nobody had come to attend to her. So, fortunately, in June that year, 2023, I had trained the doctors, I had trained the nurses of that facility on negligence in nursing practice, changing the narrative. That was the training topic. So after the training, the following week, the CMD said, come and train the doctors, went back to train the doctors on avoidance of medical negligence. So in the course of that training, I got the number of the nodal officer, more like the head of Servicom there. So when this lady called, I said, don't worry, I'm going to talk to somebody, they will attend to you. I called the nodal officer. I commend him because in less than 10 minutes after the call, when I was now calling the lady back to say, I have spoken to somebody, they will attend to you now, the nodal officer was by her bedside and was saying, Barrister, I am here, I am here, I am here. I commend him for that. But where am I going with this story? We started case. I have a relationship with the hospital, having trained their staff. This lady is a client. I wanted to mediate. Then there comes a twist. I was talking compensation. The lady says, actually, which is what fueled her anger. Saying, actually, when we graduated, I was the best graduating student, and the CMD said that the best graduating student will get automatic employment. They didn't employ me. So she was not seeking redress because she wanted to seek redress. She was seeking redress as a means to attack the institution, the facility, for not engaging her when she graduated. So I said to you people, you see, I'm talking compensation, monetary. She's saying, just give me employment. And that was the end of the case, because when I brought it up, they said, okay, we'll employ her, but the challenge is we are not employing now. So give us her details. When we are employing, which I don't know when, and I'm not in control of, we will employ her. So sometimes patients don't, or victims don't know what they want. Sometimes they make unreasonable, they ask for unreasonable compensation. They will just go, a family member say, they want to give you 10 million, they want to give you 3 million. Like I have cited example already. We did a matter in National Human Rights Commission, and the guy, they were paying you 5 million. He said, the people said, no, don't collect. How can you take 5 million for the compensation of your father's death? Till today, he didn't collect that money. And the matter has been closed. So you hear people saying, you want to compensate us, you are going to give us 5 billion. It's unreasonable. So sometimes patients don't know what they want. I've talked about abrupt abandonment of the quest for redress. You, the lawyer, you are in front. Behind you, they have settled. They won't communicate you. So when you are coming to play in this field, don't allow emotions. Some of the things I'm sharing now are experiences that have burnt fingers, time, resources, but you have privileged information now and guidance to know if we are coming in, collect your money, let the person commit via payment. If the person now wants to abandon midway, when the person is ready, the person should come back. But also remind them of limitation of action. What are the remedies? Why are we here? Remedies. You can get damages. The court can award damages. Pecuniary, you can claim for loss of employment, medical bills, particularly where it's a long-term harm, loss of income. You can, okay, now you are paralyzed, you no longer go to work. So they should compensate you for that. for non-pecuniary pain, suffering, emotional distress, you claim for that. Restitution, section 14 of the compulsory treatment and care for victims of gunshots Act 2017 provides for restitution. It says the court can make an order of restitution. So the court can actually award restitution to compensate. But my question now here is, no specific amount was mentioned. How much do you pay somebody to compensate for the loss of his or her daughter or for the loss of his or her father? If we are talking restitution, we should be talking about restoring life. How much financial value do you put on human life? Then, of course, we can go through fundamental rights enforcement. We talked about chapter 4 yesterday, right to life, dignity of human person, and all that, freedom of movement. We talked about all those yesterday. So you can bring an action here. Recommendation. Sensitization and awareness campaign. What our organization is doing is to sensitize people. That's my personal NGO. Now, what this committee is doing is sensitization. Our committee has been consistent in bringing up medical law webinar every month. Next month, we are discussing investigative forensic medical investigation, DNA and autopsy, legal and medical perspective. That webinar we hold on the 28th of October. In November, we are discussing health insurance. In December, we are discussing, God help me, motor accident medical negligence litigation. So we already have topics and speakers and dates for all our webinars. That is our own contribution as a committee to bring awareness and sensitize people. Today, we are discussing the rights of patients, understanding patients' rights. Last month, we talked about strengthening healthcare policy, the role of lawyers, the role of Nigerian lawyers. In July, we talked about organ donation / harvesting / trafficking, legal and medical perspective. In June, we talked about the use of ADR in resolving patient-doctor disputes. We talked about mental health in May. In April, we talked about emergency medical care. In January, it's only February, because of technical challenges, February and March, that we didn't have webinar. But the end of next year, we will keep having webinar from our end. Why? We say, let us empower the legal community first, so that lawyers who are learned should not be unlearned in areas of medical law. So that when briefs come to you, you have the capacity to execute that brief. We also engage with communities. 2023, to commemorate the World Patient Safety Day, we took a walk to Garki Market. We printed flyers. We went to Garki Market, engaged with people, shared the flyers, sensitized them on World Patient Safety Day and what it is all about. That is at our end. So there is need for NGOs, there is need for government agencies, I keep saying it, National Orientation Agency particularly, to live up to their responsibility and incorporate patients' rights awareness campaign into the other campaigns they have been doing. There is need for legislative intervention to enact Patients' Rights Act. We have Child Rights Act. We have Fundamental Human Rights Enforcement Act. So there is need for us to have Patients' Rights Act and also have Patients' Rights Enforcement Procedure. That way we have recognized patients' rights as a class of rights, because there's a confusion. Now, if someone is bringing a patient's rights claim, the person is forced to pigeonhole it into law of torts. Yes, it can come in there. Most times that's where it comes in, medical negligence. But we are saying now that there is need to have Patients' Rights Acts and also Patients' Rights Enforcement Procedure to make enforcement easier. Then there is need also for law reform to consolidate our patients' rights into the existing patients' rights laws into one document. So I said yesterday, our patients' rights are scattered. So you have the National Health Act, there are a few rights there. You have compulsory treatment and care for victims of gunshot, there are a few rights there. You have the Patient's Bill of Rights, which is not a law in itself, but it has chronicled some rights, more like not even a regulation, a policy document to create awareness. It is still there. So these rights are scattered. There is need to consolidate them into one document so that when you carry that document, even if it's not really an act yet, we can say these are patients' rights in Nigeria. Sorry, please, just give me 2 minutes. Let me give somebody something. Sorry, please. So, capacity building for lawyers, for judges, for them to appreciate what we are talking about. If you have a case of patient's rights violation before a judge that does not appreciate it, you know, to an extent, it will affect his decision, even or damages you award. Even if you get judgment, the compensation or damages might not be commensurate or might not be what you ought to have gotten if that same matter came before a judge that appreciates what you are talking about. Regulatory bodies also need to have their capacity built. Even relevant agencies. All this will strengthen our implementation. Then ensure accessible legal aid to indigent victims. A lot of people are suffering patients' rights violation, but we have talked about poverty as a serious challenge or barrier to seeking redress. So the legal aid should be, I know we already have a legal aid council, but awareness should be drawn. Let them know, let people know, or even a fund, because that's one of my recommendations too, the no fault compensation scheme. There are jurisdictions where there is, okay, let me follow a serial, let me not jump the gun. Ensure legal aid access to indigent victims, develop clear protocols and SOPs. This one alone will reduce, will mitigate patients' rights violation and also medical negligence. If hospitals begin to develop SOPs, standard operation protocols on how to engage. If we are doing this, these are the step one, this is step one, step two, you do this, you do this, you do this, you do this. If that is done, with time, it becomes second nature to the practitioners. They just know it by heart and continue that
It's like Mr. Ebenezer has a bit of a network issue. Let's just give him a few minutes to see if he'll come up again. He's trying to log back on. Let's just give him a few seconds. Apologies, please. He's trying to log in. There's just a bit of technical glitch going on.
Remedies.
All right, Mr. Ebenezer.
Okay. Thank you very much. Thank you. Apologies. Sometimes these things have a mind of their own. So we were talking about recommendations. So that's the second to the last slide. I'm saying that we should develop protocols. Then I'm saying we should promote ADR. That sometimes our colleagues think every matter should end in court. No. You can settle a case and have a win-win situation for both the patient and the hospital, and you still collect your professional fee. So every case must not end in court. Now, if a case has gone to the professional, gone for professional redress, just follow it through. Because once a complaint enters there, especially if there is a criminal undertone or loss of life, then we treat the person, then we handle the case and issue professional discipline. But the professional redress does not handle criminal aspects. So if the case is before the disciplinary body and there is maybe a loss of life, you can still pursue your criminal case in court. But the point I'm making is this: as much as possible, colleagues should try and promote the use of ADR. Then I suggested or recommended that the National Human Rights Commission or similar institutions should provide speedy relief and compensation too, more like having a fund set up for this purpose. That is what now brings us to no fault compensation, where I say that where there is more like the facts speaks for itself. A case of Repsis, this person has suffered negligence. Instead of putting the person through the hurdle of coming to prove another, or this person's rights have been violated, let us have a no fault. Other jurisdictions are already practicing it. No fault compensation. Did you attend this hospital? Did you go to this hospital? Yes. Did you have this injury there, or you suffered this negligence there, or your right was violated there? Yes. Okay. From that fund, you are compensated instead of putting the victim through the hurdle of proving of case. But that should not happen where it is a criminal in nature or outright medical negligence. No. Then my conclusion is this: that patients have enforceable rights guaranteed and protected by the law. Respect for these rights by healthcare professionals will build trust and strengthen our healthcare service delivery. Patients are enjoined to seek redress where their rights are violated, while government owes patients or citizens the duty of ensuring that redress mechanisms are effective, efficient, and it promotes justice for the victim. Thank you very much for your time. Thank you. So the floor is open for questions.
Thank you so much, Mr. Ebenezer. It was such an impactful presentation. So we have a few questions here, up to about 7. We have, I have 4 questions from Ms. Nasira Zubairu. I'll read them, then one from Mr. Obi and some Mr. Peter. Let me start with Ms. Nasira Zubairu. Her first question was, what are my fundamental rights regarding my exercised tissue? Then second question is, who legally owns tissues, organ, or body parts once they have been removed from my body? Another question from Ms. Nasira Zubairu is, can the hospital or a biotech company use my removed tissue for research or commercial purposes without my explicit permission?
No.
And her last question is, what is the law on consent in emergency situations where I am unable to communicate?
Okay. Thank you. Nafisat, you said that's the person's name, right?
Nasira Zubairu.
Okay, Nasira Zubairu.
Yes.
Thank you very much. For your first question, I think you need to put an explanation to it. And for your last question, it shows it's possible you were not here yesterday, talking about consent where you are unable, where you are unconscious and it's emergency. We said that section 20 says nobody should be denied treatment in emergency situation. We said that treatment should be conducted upon obtaining valid consent from the patient. And where the patient is not in a position to give consent, the patient's relative can give consent on the patient's behalf until the patient regains consciousness and stability of mind, not just consciousness, but stability of mind to be able to give consent, knowing the implications of the consent that he or she is giving. Then for your tissue that was removed, we talked about you being the patient being used for clinical research. Your consent should be sought and obtained before such research should be conducted. So your first question, please read out the question again, and I need her to throw more light on that question, the first question.
Should I read it? I should read it out
Yes,
again?
yes.
What are the fundamental rights regarding my exercised tissue?
Okay. I want to suppose that some tissues were extracted. Yeah, but I don't know the surrounding facts, what led to that. So that's why I said she should throw more light so that we understand the scenario and not just give blind answer without having the complete scenario. So just throw more light on your first question, please. But I think the other ones have been addressed. Then the next question.
The next question is from Mrs. or Mr. or Miss Obi, I'm not sure. How easily can you get a medical doctor to testify against his professional colleagues?
Okay. It will shock you that there are medical doctors who are as concerned and as passionate as we are here doing this webinar. 2 days ago, or 3 days ago now, no, 4 days ago, on the 16th, today is 19th, 3 days ago, I said I was at a technical session. The person, one of the facilitators, cited his own example. You know, I used to say, yesterday I gave us an assignment. I said, close your eyes. Think of anybody, close your eyes for 10 minutes. Think, and if you find it difficult to remember one name you know who has lost his life due to medical negligence or patient's rights violation, you just for 10 minutes, you don't remember somebody you know directly or somebody whose brother or friend or auntie or a story you have heard about that. If you don't remember, type it on the comment section. Because they are all humans, they are also affected. The chair, the convener of that technical session, so to speak, was regretting the loss of his father-in-law. He said his father-in-law had tetanus. He was managing his father-in-law himself and just left him in the village to come and do something in Abuja. And they say there's a challenge. He gave his story. They used his car to convey him to the hospital. And they gave the man one injection. The man said, I have not forgiven those that caused the death of my father-in-law. So it is very easy to get doctors to come and testify. We worked with a former chairman of a committee of NMA that is into cracking down quacks. They are regulating one of their subcommittees. He was the chairman. And he doesn't want to use his left ear to hear that doctor is doing malpractice or is negligent. So it is very easy. And we, for our dear healthcare practitioners, I keep saying it, it is not an attack against the individual healthcare practitioner. It is not an attack against the medical profession. It is our collective effort to build an effective and responsive healthcare service delivery system where we can all go in confidence that we'll come out alive. They are doctors, sir. There are nurses who are fed up with what is happening because they know they can be the next victim, and they are doing all within their capacity. I went to observe a session before the Medical and Dental Council, and if you see how the professors on the panel, there is this misconception that people outside, doctor, they protect themselves, so nothing will, if you write petition, nothing will happen. I will tell you free of charge, it's not true. Let that petition get to Medical and Dental Council. The members of the panel themselves, in fact, one of the challenges that gets the most of their decisions upturned when it is challenged on appeal is because sometimes they don't know. As a panelist, you have to be an unbiased umpire. Sometimes they descend into the arena out of emotion, out of anger. So the doctor has his lawyer, the tribunal has their own panel there. Then sometimes the panelists begin to descend into the arena to speak for the victim. That is how angered they are. So you can get doctors to come and give evidence against their colleagues. Thank you.
Then we have a third question, another question from Mr. Titus Tarfa. He said he's asking, where is the right of a patient who is being rejected on the number of hospitals on the ground that there is no medical facility to admit him or her, and he eventually died on the way while moving to another hospital in a case that is an emergency?
Okay, the patient, that victim, the family of the person can sue. Now, we have reemphasized again that Section 20 prohibits that. There is a difference between referral and rejection. If the hospital wants to refer, the standard procedure is to examine the patient and write a letter of referral or a note stating what they are lacking and why they are referring the patient, what they have observed, and why they are referring the patient to this other facility. But to a situation where a patient is dismissed, that's what I call it, dismissal. That is not referral. The patient's relative can sue. So what they need to know is the name of the hospital. Then they need to know the doctor that attended or healthcare professional that attended to them at that particular time. Because today we are talking patients' rights. Maybe in subsequent webinar, we create time to talk about patients' responsibility, one of which is to know the name of your healthcare provider, the person that is attending to you part-time. It's your right to know the person's name. It's your responsibility, rather, to know the person's name. So they have a right, they have a claim. They have a claim.
So should I read out the next question?
Yes, please.
So the next question is from Mr. Peter. He asked, what is the liability incident of a hospital that refuses to attend to gunshot victim, leading to the death of the victim?
Straight away, you can sue the hospital and you recover. I said it a while ago that Section 14 of the Compulsory Treatment and Care for Victims of Gunshot Act 2017 has brought in restitution, that a court can make an order for restitution. Section 1 of that act says that hospitals in Nigeria should receive and treat persons with gunshots with or without police clearance. Subsection 2 of Section 2 says that the hospital should receive and treat such a person with or without initial deposit of funds. Because Section 11 of the National Health Act has already made provision for basic healthcare provision funds, which I told us yesterday that is already being implemented by the Federal Ministry of Health. So a hospital that denies or rejects or refuses to treat a gunshot victim on the ground that the person did not present hospital police report is liable, because the law since 2017 is no longer a requirement to treat a gunshot victim. So the hospital is liable. The person needs to sue the hospital. But before suing the hospital, the court is not Father Christmas. I talked about evidence gathering. You need to show that you actually went to this hospital. They actually rejected you. This person was the person on duty. This person was the person that refused that treatment. Then that this person now dies as a result of the rejection by this hospital. Now, on the contrary, if the hospital says we will not be able to handle this case, then the hospital writes a letter and gives you to go to hospital B, the hospital has rendered a valid healthcare service, because it will be of no use to keep a patient you cannot cater for. So where the hospital refers properly, they have rendered a health service. But where they dismiss or reject, they are liable. Any other question, please?
Yes, so there's one from Mr. Adiremi. The question is, where medical negligence on the part of a private hospital has occurred that necessitated that the patient be urgently rushed to the Federal Medical Center, JABI, where despite all efforts, the patient eventually transited to eternity. What should the family who don't want the stress associated with prolonged litigation do, apart from their demand for outstanding money from the hospital deposited at Lima Hospital for vital tests that were...
I will prefer we don't call hospital the names of institutions. Now, I did say so. Is the question, have you finished the question?
So the last part of the question was for vital tests that were charged for were not done.
Okay. Now, I said this, hospitals are not magicians. Doctors are not magicians. What the doctor owes you is competent care. There are laid down procedures of treating or attending to each ailment. Where the doctor has done what he's supposed to do and a patient still dies, the doctor is not negligent. I need us to get that balance. It's very important. If you drag a doctor before the Medical and Dental Council, the council is not going to look at whether the patient died or survived. The council is going to look at what steps did the doctor take, what procedure did the doctor follow. If the doctor followed the right procedure, he will be absolved of all responsibility, or liability rather. He is not liable. But where the doctor is found to be negligent, for example, the doctor is supposed to check on the patient every 2 hours because of the injection he has given, and he didn't check the patient for the next 5 hours. That is negligence. The doctor could go in if it is proved. But where the doctor did what he is supposed to do and the patient still dies, the doctor is not liable. So in this case, the patient was in hospital A, and hospital A referred the patient to hospital B, and the patient gets to hospital B and does not make it. We should look at intervening factors. What happened in between hospital A to hospital B? What was the condition of the patient? Was the patient supposed to be on oxygen? At the time the patient was going to hospital B, was there an oxygen on the patient? So we should look at intervening factors, because you have said from a place of, okay, family friend is your person. I was in hospital A, and they referred us to hospital B, and the hospital B, we got there, the patient died. So we need to know, and this is where autopsy comes in. Where the patient died, what autopsy does is to show what killed the patient. If the patient dies of natural cause or died of natural cause, the hospital will not be liable. If the patient now died as a result of maybe overdose of a particular medication this hospital A had given, or something else that hospital had done, or hospital B had done, we now know where to place the liability. So the facts before us now is incoherent, so to speak, is incomplete to make a decision on it. But generally speaking, where there are also cases, we must admit, where patient's relative brings somebody in dead, but their belief in faith, they may not have known, firstly, that the person has died. Then they believe in faith that the person, once they enter this hospital, the person will be attended to. And they get there and the hospital says, this person has died. The first reaction is to live in denial. So we must balance this. The first reaction is to live in denial. The patient family does not accept or agree or believe that their person has died. Then they quickly blame the hospital on that. There are also instances where hospitals are negligent and now use brought in dead. We talked about delay. So when they delay and the patient dies, their defense is that the patient was brought in dead. So, like I said, if it is a case of delay, hospital B will be liable. Assuming the patient came in and they delayed in attending to the patient and the patient passed on, hospital B will be liable. Assuming an autopsy was conducted and whatever killed the patient had occurred in hospital A will be liable. But we don't, you see the first position. The family we talked about barriers to seeking redress. The family has already said we don't want to go through the stress of litigation. Now, before you litigate, have you even buried the person? If you have not, because litigation is evidence-based. If you have not buried and you want to go to litigation, the first thing you do is autopsy to find out the cause of death. That will now help you in preparing your case to even know whether you should go on with your litigation or take closure with the knowledge of the cause of death, where it is natural or a natural consequence. If somebody has cancer or other terminal ailments at advanced stage, at that point, what you do is management. But where you now move that person from hospital A to hospital B, we already know that cancer is terminal. Now, that is not a defense or justification for poor treatment. So we must bring a lot of factors to play because there is need to understand that doctors are not magicians. What they owe you is competent care and not a miracle. So what the law will look at is, has he followed the procedure? If he has followed it, the doctor will be exculpated. Thank you.
So, Mrs. Nasira threw more light. Let me go into it. So she said, what she meant was who legally owns the body part. For example, assuming a limb is amputated, who legally owns the body part once they have been removed from the patient after a surgery? Does it automatically belong to the hospital to do with it as they will, or can the patient request for it to dispose of it
To
themselves?
dispose of it. The patient can request. The patient can request. The patient can request to dispose of it. But what do you need that for? That's my question. I'm asking the person asking the question. Do you understand?
Yes.
Do you want to put it in a glass and be looking at it to see your leg? So it is your body parts. It is your body parts.
She said, I read in the terms and conditions of a private hospital in Abuja that was stating the part belongs to the hospital, but it didn't feel right. But it didn't feel right when she read it.
Okay. Now, beautiful. Now, You see, I say there are express and implied terms. You have read this and you say you don't want, you have a right to not engage with that hospital. They have given you expressly. You have a right to say, I will not do here. Or you have a right to say, in my case, when you are done, I will need to have this for A, B, C, D. I will want to, when people give birth, when women give birth, the placenta is given to the father of the baby to go and bury. The hospital doesn't keep it. Do you get? So it's your body parts, commonsensically and legally too. You can demand, but the question is, you are not a trained medical personnel. What if it is infected body parts? What if it is infected? What are you going to do with it? Even if you want to go and dispose it yourself, if you remember during COVID, people were, because a lot of factors will come to play. During COVID, loved ones were deprived the opportunity or honor to even touch to bury their dead. Do you get it? So a lot of issues, public health emergency issues is around it. So if it will be in overriding public interest, they can deny giving it to you. Yes.
So the next question is from Mr. Dennis. He said, if a doctor operates on someone who broke his bone and after the operation discovers that the bone wasn't aligned well and the doctor asks for more money to correct it, what can the patient do? Should he sue or pay the money?
Okay. A patient had an accident, maybe fractured bone, and the doctor made a mistake, and after surgery, the bone didn't align, and the doctor wants to do a corrective surgery and is now asking the patient to pay more money. Now, that's another issue. The patient needs to be strong first. The patient should not be fighting with an unhealed wound. One, that's me. The wisdom here demands that you get well, either in that hospital or in another hospital. But you can also insist to say, no, this is corrective surgery. You didn't do it right. At that point, you can take up a claim against the doctor. This one, you will need professional redress first, because it makes your legal redress easier. If you go through the professional route and you have you secured a conviction or a decision in your favor by his professional brethren, when you are putting up your legal claim, you also plead the fact that his professional colleagues or disciplinary body have already condemned this act, and you plead that decision. So it strengthens your case and makes the court to be on your side from start, knowing that this person before me, his professional colleagues have already said that what he did was wrong. So I do not think that any doctor in his right senses will ask for more money to do a corrective surgery to correct the error he made, especially if he's dealing with an awoken patient. I use awoken to describe a patient that knows his or her rights. Any other one that doesn't know is sleeping. So you can decide, one, to go to another hospital and get proper medication and now sue this doctor. Not even sue, go before the Medical and Dental Council first. Then you now proceed to court. If you can also decide to pay him, then get treated properly and file an action to recover that payment you made.
Okay, so this is the last question. We need to wrap up. We're almost out of time. So this question is from Hadiza Mohammed. She said, what kind of legal action can a family member of a deceased person take for a longer operation hours? The patient was told the operation will only take maximum of 2 hours and ended up for up to 6 hours in the theater. According to the doctor, the patient died of cardiac arrest during the surgery, which the patient had never had never had medication history of heart disease. Furthermore, the doctors refused to give death certificate and keep on missing appointments for the certificate collection.
Okay. Now, in this type of case, this is where you do autopsy. The doctor has already given out information as to the cause of death. So your autopsy report will be to either corroborate or counter that cause of death that the doctor has given. So where the doctor has given, say this is the cause of death, and you are saying this person has not had a history of cardiac arrest. If the doctor had said blood pressure, it could be possible. But now he's saying cardiac arrest. So you do an autopsy to get a report that counters that of the doctor. But where the autopsy report corroborates what the doctor is saying, then you have closure. You are saying the person has not had cardiac arrest before. How do you know yourself? How do you know? But as for the longer, because what this person is claiming now, the question is like, assuming they completed the surgery within 2 hours, this patient wouldn't have died. That's the reasoning of the person who asked this question. The doctor said this thing will take only 2 hours. Then he goes into the theater and they are staying 6 hours. What were they doing again within 4 hours if the surgery was that easy? So it is within they must have made a mistake and they are trying to correct it that now made your relative to pass on. Well, the standard procedure is that consent is specific. You need, because it's invasive surgery now, if you're doing theater, consent is specific. This is what I am going in for. Now, it is possible that the doctors have opened the person up and they are seeing another thing. Example, a lady goes to deliver a baby through CS. In the course of delivery, they have opened this woman up. They have brought out the baby. They now see ovarian cyst. By the rule of consent, if that ovarian cyst is not a threat to life of that woman at the moment, if it is not life-threatening, the standard rule or procedure demands that they close that woman up. Now tell her, madam, when we opened you up, we saw ovarian cyst. This is this. Then the woman can now decide to take it out. Some person might say, why did you not remove it? You saw it there, you didn't remove it. Now the woman went in for delivery, not for ovarian cyst removal. Another, but what is common in practice, medical doctors will say, once we open a patient up and we see anything that will become a threat, whether now or in the future, as we have opened the patient up, we will remove it because we are acting in the best interest of the patient. Now you see that these two principles is tensioning each other. The patient's rights to his body to determine what should be done. Now, in this case, we are not in the theater. We don't know what the doctors saw that prolonged the surgery beyond 2 hours. Assuming it was for delivery, and they went in and they now saw multiple fibroids, and they now decide to remove it, and they have delivered the baby safely through CS, and they now saw multiple fibroids, and they now decide to remove it. We do not know. So again, we will need to have more facts because this is a webinar. I don't want to turn it. In fact, let me even issue this disclaimer first. This is not, firstly, of course, you know that I'm not a medical doctor. So there is no medical opinion here, and there is no legal opinion being given, but we are just learning to broaden our knowledge. If the person now wants legal opinion, let the person come and pay for consultancy, and we will take up. And
We have two more questions, but we are out of time. Should I send it to you on the WhatsApp platform? Because they're like, should I read it out?
Question.
Should I read it out?
Okay. I am thinking there's also there's a question on YouTube.
Okay,
So,
let's take from YouTube.
Okay, so it is pretty lengthy. I am going to try to read it. Okay. Somebody so it's from Blessing, Mr. Blessing Ogu. He said a pregnant lady went to a medical facility for delivering. It turned out she needed to deliver through cesarean section. This medical facility didn't have the capacity, so she was referred to another medical facility. Now, the twist is that the facility didn't blood pressure was over the roof, and the second facility started high blood pressure treatment.
We lost you somewhere. Can you hear
me?
Yes, we lost you when you said the facility didn't have the capacity to take the delivery.
Yes, they didn't have the capacity for the cesarean section, so she was transmitted somewhere else to another facility. When she got to the second facility, they discovered that her blood pressure was over the roof, and so they started her on high blood pressure treatment so as to stabilize her blood pressure. Now, the treatment made the bleeding worse. Apparently, she started bleeding, and it led to an hemorrhage. And the doctor had to conduct a C-section. Now, she got massive blood transfusion, and then they stopped the high blood pressure treatment. When they now demanded for a medical history from, I'm guessing, the first facility, it was discovered that the first hospital did not even send it along with the patient. And then her husband now had to go back to the first facility to get the record. And when this new doctor saw the record, he was shocked because if he had seen the record, she would not have been placed on high blood pressure treatment because it was an emergency. Well, luckily for him, the drug that was administered did not counter the high blood pressure, and eventually the bleeding stopped. Now, they successfully conducted the surgery, the mother survived, baby survived. Now, his question is, what could have been, who will have been held liable if the woman had died? Will it be the first hospital that did not transmit her records, or the second hospital that acted on the emergency without forcing a record?
Now, this is largely academic and speculatory because he's saying assuming. So I will leave it at that point. It is speculatory and largely academic. But let me answer by saying this, that the first hospital that did not transmit along with the record, they have a case to answer. The second hospital that also treated without seeing the record have a case to answer. But don't forget that they were acting on emergency. We said a patient who is brought in on emergency situation should not be refused treatment for any reason. So if the doctor in the second hospital has said, okay, madam, you people should wait, let them go and bring your medical record before we start treating you, the woman might not be alive. So the second hospital was acting on the spur of the moment to arrest emergency. The question now is, the steps he took, are they the right steps to be taken? Another question is, if he had seen the medical record, which he confessed, that if he had seen this medical record, he wouldn't have taken this step. So the case has already resolved itself. But assuming the woman died, more liability would have been on the hospital A that did not, more liability, not that hospital B is totally exonerated. The defense of hospital B could be section 20. But this person has just narrated his own. We do not have the remaining facts. So before you take up a brief or agree to take up a brief. When the patient, when your client has briefed you, always ask further questions to get as much facts as possible, because the surprise revelation might come, and at the end of the day, you will look foolish and stupid. Even when you have prepared your case, keep asking questions, keep probing. Also, consult. You are a lawyer, you are not a medical personnel. There are cases that will come to me. The first thing I will do, I will pick a phone and call a doctor and say, this. There was a time we were doing a matter that involved cross-examination, that involved autopsy and all that. I had to call. I had to do a research on the procedures, the legal procedure, what should be done, 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 preparatory to that case. So when you are getting far, because the person tell you, please have this at the back of your mind. Anytime you are being briefed of medical negligence or patient's rights violation, as the person is talking, be hearing it in your ear: emotion, 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 emotion. Facts from emotion, because there will be likelihood of embellishments. Thank you very much. Okay, I think we should be.
We have two more questions. Can we just take it?
Adisa, please let me just ask one question. I saw a question earlier that someone had asked, and I feel it's quite important. It was asked by Michael, and it's asking, for people who are interested in building capacity in medical law practice, do you have law reports, textbooks, resources that they can access as a way to start building their capacity?
Okay, this is a very interesting question. I think it was last week or 2 weeks ago, I facilitated the webinar for the Young Lawyers Forum on HR branch in Anambra, and the theme was career prospects in medical and health law in Nigeria, medical and health law practice in Nigeria, or something like that. And in that webinar, firstly, thank you for asking that question. In that webinar, I said that the first port of call is knowledge acquisition, capacity building. Read, study, get trained, attend webinars.
It seemed to be a network problem.
Today, I'm talking to you here now. 2013, I was into medical law practice. Nobody knew me. 2015, I was doing medical law. 2017, I'm saying, do you get it? 2019, 2020, as at 2019, I have been settling case. Nobody knew me. But by that time too, I had been going for trainings. So there are local authors. I will gladly recommend my professor to you, Jesus Christ. What did I do? Okay, I thought I deleted this thing. I will gladly recommend my professor to you, his book, I think, Principles of Medical Law and Ethics in Nigeria, or something like that. Yes, Principles of Medical Law and Ethics in Nigeria. It's written by Professor Celestine Wakwe. He's my medical law professor. The book is around 30, 25, between 20 to 30,000, 25 to 30,000 now. It's a good book. It's a rich resource. It's a good place to start from. There is this book, God help me now. There's this book, Medical Law, just written by or Yinka. Yes, but God bless his soul. I learned he has passed. Then there is this book, Lawyers in Snake is in the Courts, written by Emmanuel Obong. Snake is in the Courts. These are local authors that I'm talking about. There is this one by Professor Tabo, Dr. Tabo. God help me, what's the name of it? Something on medical law and ethics. There are local books now. Thank God we have. And then there is Professor Dada. God help me. Medicine and the law. Legal aspects of medicine. I think something like that. Legal aspects of medicine. Something like that. Yes. Legal aspects of medicine by Professor Dada, University of Calabar. So there are local materials. Go to the net. There are materials there. Seek out online trainings. There are materials. Read journals. Belong to associations. Join communities. That is the only way we grow. When I finished the webinar for, what's their name, Young Lawyers Forum, and they asked the same question, I said join communities. 2 people individually, one sent a message, followed me on Facebook, sent a message. Between that last week, she should be here too. Between the webinar and today, the person had attended or participated in not less than 5 medical law activities, because the person is now in a community. If you didn't attend this webinar, you wouldn't know. 2 days ago, 17th, I was on NTA, Nigeria Today. Is that the, yeah? Nigeria Today. I sent it to her. I say, join, listening. I was on Radio Nigeria, on Capital FM. I sent it. I say, listening. I had a speaking engagement at the. I sent it. I say, listening, because the person is now in a community. Members of my committee, including the moderator, we are in a community. So if I see anything happening outside, we bring it inside. Damilola, if she sees anything happening outside, there's this training here, she puts it on the platform, you log in. That way we are building capacity. Why? Because we're in a community. So the person that asked this question, the first community I will refer you to, go and join SLP. If you are not a member of SLP, that is a session on law practice, go and legal practice, go and join. If you have not joined, next year when you are paying your practicing fee, there's SBL, there is PDL, and there's SLP. So in addition to any other one you belong to, go and join SLP. When you join SLP, SLP has different committees, one of which is Committee of Medicine and the Law, or the Law and Medicine. Go and click and join that committee. So you are already inside a legal committee or a community of lawyers that are into medical law practice. So if there are activities happening, that is how you will know. There are always conferences, but because you are not in a community, you won't know. That's the starting point. Then follow the news to know what is happening outside in terms of the health sector generally, because you are now a player. As a medical lawyer, you are already playing in the health sector. Follow what is happening. Read up. If the government is formulating a policy, if a law is passed, follow it, be current. Then pick up journals and read along this line. Then subscribe to Nigeria Weekly Law Report. There are law reports. Yesterday I was citing cases. There are Nigeria cases. Now, the Benue State case I talked about is 2025. the 250,000 naira case is 2025 that the Court of Appeal, I think, just either June or July, or June or May, that the Court of Appeal, Macaulay Division, gave that decision. So it's because I'm in the community. That case is not reported yet, but I have access to it because I'm in the community. Okay, let me not go into that. There's a Supreme Court of Appeal decision that validated or upheld the decision of a lower court awarding damages of, I think, 1.5 million or so, or 2 million, to the victim of medical negligence. The doctor appealed. The Court of Appeal upheld the decision of the High Court in FCT here. That decision of the Court of Appeal is not up to 2 months, but I have that judgment because I am in the community. That case is not reported. So the issue is, find yourself a community and join. What I'm going to do, I've already, because these people ask the question, they say, how do we get to know when webinars are coming up? This platform is a community. We do webinar every month. So if you follow us from January till now, you would have participated in all the webinars we've done. You are building knowledge, and it will shock you. You will think you don't know anything yet. You will think you have not built capacity until a case is presented to you. And from your reservoir, this knowledge will be coming. Again, if you see opportunity to volunteer, volunteer. If you see a law firm that is into medical law practice, volunteer. If you see an NGO that is into health, volunteer. In doing that, you're building capacity. Thank you very much. Please, you have to take my Oga. My Oga has raised his hand. Dede, good day, sir. Please, unmute Mr. Obi before he pursue me. There's a hand raised. Mr. Obi Anwonye, please unmute him. Now, my Oga.
Yeah.
Good day, sir.
Thank you. Thank you very much. It's a wonderful job. Like, people have been commenting, there's nothing like this, honestly. You are doing a great job, you and your team.
Thank you, sir.
Are we together?
Yes, sir. I said thank you, sir.
Okay. Okay. Let me quickly ask, you know, this concept of deep pocket principle in thought, if there's you want to take up an action against a doctor, do you sue the doctor, the hospital, and join the doctor, or sue the doctor and join the hospital?
Okay. Now, that is a brilliant question. Thank you, sir.
Yes, sir.
When you want to sue the hospital, in fact, let me even say this, even though this one is for paid consultation, but let me say it's free of charge. Some lawyers miss it from the parties already. From the parties. Sometimes, let's say the name of the hospital is ABC Hospital. That's what you know. You go and sue ABC Hospital. And you now get to court and you discover that ABC Hospital is not a juristic person. It's unknown to law. So you do your investigation, you sue the registered trustee, you sue the board. You find out the nature, who are the people behind this hospital. Then straight to your question, sir. When you are suing, you look at the people that are involved. Firstly, the doctor, you can sue the institution, then you join the CMD. But the challenge now is, or rather, the more you have people joining, because in fact, there is even how do I put it? There is suggestion and quarters. You should join the age. But you know, once you join the age, you have picked up a fight with a big weight. The age is the federal government, because that's the pocket principle. so that if you are claiming damages of 10 billion, you have a party that has that financial muscle. Is it not? But the issue is now, if you have joined the age, because once you join the CMD, automatically is the government, because he's appointed there by the government, then the age is joined, you now have more people, more weights that will also counter you and match you power for power, money for money. Do you get it? So what you do is you streamline your parties. First, who is directly involved, you pick that person. Secondly, the institution, you pick it. Thirdly, who is the head of this institution, you pick it. With this, you have covered your party. If there are other persons who any decision that will be given by the court will affect, or who played one role or the other in the chain of events, you join them, so that you are able to get, because if you are trying to pursue deep pockets, you will need to join. In fact, once you put a CMD now, they will bring it to AG. That I'm telling you an insider information now. As you're joining the CMD, the AG, the AG will come in. So if you're getting your parties, there's nothing wrong in joining the CMD. You join, but make sure the people you are joining, first of all, are the necessary parties to get your case granted. Then you join the CMD, of course, or the head, if it's not the CMD, the head of that establishment, you join the person. Then your claim should also be reasonable. But like I said, litigation should be the last option. When you are doing medical negligence case, your goal should be, what do I get out for my clients? What do I get out for my clients? Not just let me go and show them that I'm a lawyer. What do I get out for my clients? Whatever option is brought to the table, weigh it, confer with your clients. Sometimes you also advise. Now, that does not in any way limit your pursuit of justice. But I'm saying that sometimes our people, our colleagues are in a hurry. And again, sensationalization of cases, I forgot to mention that. Sometimes our colleagues are in a hurry. As soon as something happens, they have not even gathered their facts. They put it on the media. Media needs news. The media starts telling their own story. It now becomes a battle of narrative. Before you do all that, get your facts, get your evidence, put your house in order. It is not about showmanship. No. What do I get out from my clients? What is the easiest route to get this thing out? What do I do to get justice for my client with minimal resources and minimal time? Thank you, sir.
Thank you so much. I appreciate it.
Okay, I think we have attended to all the questions. 1, 2. Let me just thank everybody. I don't know how much time we have, but I want to. Okay, do we have questions so that it doesn't look as if I shot people out?
We have 2 more questions that we've not answered.
Okay, let's take them. Have you read them?
No, I haven't.
We are not taking any other question after this.
Like 5 minutes.
What?
Okay. We are not taking any other question after these 2, please.
Okay. So I have one.
Damilola, is it possible to put out a form? Let people fill their name and phone number so that we create another community for people. Is it possible quickly put out a form just for the committee, not for ICLE? Put out a form, just a link, just your name, phone number, and branch or email address, your WhatsApp number, so that we can collect and get another this thing. I actually have my personal group, but I don't want to add this to that personal group. I don't want to. So please, let's do that. Thank you.
Should I read out the question?
Yes, please.
So we have one from Mr. Okpi. The question is, given the high threshold of proof in negligent cases, what legal strategies can patients realistically use to succeed in medical malpractice claims in Nigeria?
People have been succeeding in medical malpractice claims. It is just know the expertise. What do you need to prove in medical negligence? One is duty of care. The doctor owes you a duty of care. So you prove that you went to this hospital, you engaged with this hospital. One. What else? Breach of duty. That this doctor has breached this duty of care he owed you. Three, that you suffered damage. You suffered harm as a result of breach of this duty. Then that brings the linking element, causation, that you suffered harm because this person breached his duty of care. So that would 1, 2, 3, 4. 1, duty of care established. You can't just wake up from nowhere and say you want to sue a hospital. So establish a relationship between you and the hospital, duty of care. 2, establish that the hospital has breached that duty of care. I told you what a hospital or a doctor owes you is competent care. So I engaged you, you were incompetent in treating me. So it's a breach of the duty of care. 3, because of your incompetence or I suffered harm while in your care. That is harm. Then 4, causation. You must link it. There's a case I don't want to call. It's my respected of God that did that case. I was saying he proved duty of care. He proved breach of duty. He proved harm. But there was no causation. Even though they had evidence of causation, they didn't just plead it. They didn't just plead it. The man has said, I do not want surgery. And he wrote and signed. The hospital gave him consent form to sign. He said, I don't want surgery. He wrote it with pen. I don't want surgery. And he signed it. He signed a consent form, but wrote on top, I don't want surgery. The hospital went ahead to do surgery. During cross-examination, they asked the man, did you understand? The hospital explained to him, said, did you understand what they explained was going to be done to you? He said, yes, I understood it. But I said, I don't want, I wrote, I don't want. Did you understand? He said, yes. Now, they also had evidence from another hospital that showed that what this man suffered was because the surgery done on him was not properly done. Unfortunately, this report from the second hospital, which is causation, was not pleaded. So, assuming that document was pleaded, the case would have been resolved in their favor. So, proof of negligence, where the challenge is in evidence guarantee of witness. And that's where technical expertise comes in. That's what I'm saying. You have seen it as burdensome, but it is not. Even though it is weighty to prove, I'm saying this because I have the privilege of knowing. But if you have these steps, duty of care, breach of duty, harm suffered, and causation, you are good to go. But you need to get your evidence to establish all this. Thank you. Let's have the last question.
Then the last question from Mr. Uluwatosin. What happens when an appendicitis patient scheduled
Go ahead.
Patient
appendix patient.
Appendix patient scheduled for surgery was left by the doctor so they could perform a cesarean section and died after surgery when he was eventually attended to.
That is delay. So they need to prove all this. That is delay. The patient had been stationed or scheduled for a surgery. And all of a sudden, they now abandon this patient to go and attend to another patient cesarean section. Now, that is a breach of the ethical principle of justice. I was talking about certain pillars of ethics, yes, medical ethics yesterday. One is the principle of non-malfeasance or beneficence to start with. Do good, act in the best interest of the patient. Then non-malfeasance, do not do harm. Then one of such principles is the principle of justice, equitable distribution of resources. Now, you do not discriminate. We don't know who that patient that walked in is. What if it's the wife of a commissioner? What if it's the wife of a governor? What if it's the wife of a senator, wife of honorable member? But that life is not more important than the life of that appendix patient. So the principle of justice demands that since this appendix, because appendix is also life-threatening, we don't even know whether it has ruptured. We don't know whether it has ruptured. So if it is established that this patient was brought in and was scheduled for surgery and probably was wheeled into the theater or had been told, we will commence your surgery by 10. Then by 10 o'clock, they now tell him, okay, let us attend to this woman that just came now. We don't know what is appendicitis, so we don't know. But there is a lot more to prove. So what you need to learn as a medical lawyer or prospective medical law practitioner is evidence gathering. That's where you win or you lose your case. Evidence gathering and presentation of your case. Thank you very much. So I want to sincerely thank everyone who has patiently waited till this moment. Without you, of course, we will not have this webinar. I want to thank our committee members from the moderator yesterday, Amara Chukwu, Dr. Amara Chukwu Ezetulugo. Amara has doctorate degree in medical law. So when you hear Dr. Amara Chukwu, she's not a medical doctor, she's a medical lawyer. So I want to thank her in absentia. I want to thank our able moderator, Hadiza. I want to thank our technical person, Damilola Alabi. I want to thank every other member of the committee. And of course, my organs at the top who are here. Obi, good afternoon, sir, once again. Thank you. I want to thank Professor Osimen. Prof joined from out of, in fact, Prof made a lot of sacrifice to join yesterday, and I'm sure he's somewhere today, either on YouTube or Zoom here. Thank you, Prof, for joining. All my friends from the medical community, you know I love and regard you, and we're in this together. Thank you all. Next month, I have said earlier, we are coming back on the 28th of October, and we will be discussing forensic medical investigation, DNA and autopsy, a legal and medical perspective. So look out for our flyers, and also tell your friends. We do this every month, to build your own capacity so that you do not become the reason why a patient will lose a victim of medical negligence will lose a good case. Thank you very much. Have a blessed day. Goodbye.
Thank you, everyone. So in the next 3 minutes before the meeting eventually shuts down, I'll keep reposting the CPD form. Kindly fill the form. The link will only be active for the duration of this webinar. After the webinar, the link will no longer be receiving responses. So for the next
that means, 2 minutes. What about our second link? Were you able to create it?
Which second link is that, sir?
The one I said you should create for the phone numbers of those who.
No, I couldn't do that.
Okay, no problem. So in our subsequent webinars, we will find a way of getting that. We just put out the form and build a community where we can, even those other knowledge sharing platforms we have, we can make it available so that we all grow together. Thank you. This platform is a community. We do webinar every month. So
we're counting down now in 1 minute. So this is the final call to fill the CPD link. Kindly fill the link.
And it will shock you. You will think you don't know anything. You will think you have not a good capacity until the case is presented to you. And from your reservoir, this knowledge will be coming. Again, if you see opportunity to volunteer. You see a law firm that is into medical law practice, volunteer. If you see an NGO that is into health, volunteer. In doing that, you're building capacity. Thank you very much. Please, you have to take my Oga. My Oga has raised his hand. Take a good day, sir. Please, unmute Mr. Obi before he pursue me. The hand raised.
In touch. If there's a
So I'm counting down now. 10.
You sue the doctor.
9. If you're having challenge filling the link, kindly change your network, check your browser. We have had more than 100 responses on this link, so the link is actually working and open. But the link will no longer be accepting responses after this webinar. So please, 9.
When you want to sue the hospital,
8.
let me even say this, even though this one is for paid consultation, but let me say it free of charge.
7.
Some lawyers need it from the parties already. From the parties. Sometimes,
6.
let's say the name of the hospital is ABC Hospital. That's what you know. You can sue ABC Hospital. And
5.
you now get to court and discover that ABC Hospital is not a juristic person. It's unknown to law.
4.
So you do your investigation, you sue the registered trustee, you sue the board.
3.
To find out the nature, who are the people behind this hospital. Then straight to your questions.
2. And for the last time,
the people that are involved, especially the doctor,
thank you for joining us. Make it a date with us next month. You can follow, you can check, you can catch a replay of this webinar and all previous webinars of the committee on the MBA Gariki branch, Abuja. YouTube link, yes. And to know when next we're having our webinars, follow us on Instagram, MBA Gariki branch. You'll find updates on the webinars of the committee on the Instagram page. And on this note, thank you very much. Enjoy the rest of